Hey, everyone. Thanks for joining me. So we got a bunch of people in the chat already, so that's awesome. Hey, while we're waiting, can somebody go and post the YouTube link on Twitter, because I forgot to post it. And I meant to. I could actually just do that right now because I'm seriously like right here. My glasses keep fogging up. So I hope everybody is doing well. Let me see here. Let me get the link. So I hope everybody is doing well. Turn off the volume. There we go. Sorry. Copy. All right. So, okay, you guys. Well, tell me in the comments. What are your thoughts? How are you feeling while I'm waiting? Because I'm waiting until some more people show up. I can't type and talk at the same time, so please. Probably spelled something wrong. I hate Twitter. Fuming. Okay, I'm going to tell you guys right now that, you don't need to be fuming. You really don't. Disappointed, yes. Hi, it will say, I'm just letting everyone know, if you're on Facebook, it's going to say Facebook user, and it won't tell me who you are. I think you had to let StreamYard know who you are. So if you want, just put your name there so I know who it is that I'm talking to. Whew, I am sweating my butt off. My office is like 90 degrees. There's no air in here. So yeah, so if you're on Facebook, I can't guarantee that I know who you are. I'm not being rude by not saying your name. I literally just got out of the shower. This is why I'm sweating like crazy. I was so gross. I've been up since 4:45 this morning because, as everyone knows, I'm a diehard gymnastics fan and I refuse to be spoiled by anything. So I have to watch it live, and it's been a crazy sleep schedule. So I'm working on no sleep. Hi, Allie, Marilyn, Lori, Ann, Dana, Alice, Sheree, Kelly. Thanks, you guys. Jinxie, are you here? I see someone saying hi. Crockett. Thanks, you guys. I'm just, hi, Sue. Again, I'm just killing a little bit of time because I want to make sure more people are in here because I don't want to repeat myself a whole lot. But I'm telling you right now that, like I said, this isn't a complete disaster, okay? It's bad. It's disappointing. I was just gutted when I first saw the actual, that they affirmed it. But it's not all bad. When you actually read it, there's some good takeaways from it. So I just want everyone to climb off that ledge that they're on and know that there's still a little glimmer of hope here. It's not the end. I will give you some hopeful news. Hi, Stacy. I feel like I haven't talked to you guys in so long. See, I have to look up because my StreamYard is up on my other monitor because I want to be able to read the document down on my lower monitor. So sorry about that it looks weird that I'm looking up. It seems weird to look straight into the computer here and then be looking at the comments. So yeah, I will get you off the ledge. But there's still things, that I can understand being upset about. I have got to get my glasses to stop fogging up. I have been nonstop going since 4:45 this morning. I seriously it's craziness. It worked out really good though, because the gym competition ended at 8:30. And I was like, okay, just in time for the opinion. And then I had to work this morning, and my 3-hour part-time job turned into like a 7-hour thing because I was so busy with other stuff. That's okay, Allie. I'll take a birthday cake. I didn't see you guys on my birthday. It's only a month past my birthday, so it's not that bad. Oh yeah, Justice is making appearances. I always forget. I'm so used to her barking that I don't even pay attention to it most times unless she doesn't stop. I'll close the door if I have to, but she doesn't like that. So I wish I had a fan. I could bring a fan in here, but then I'd feel like my hair was blowing and I'd look like I was like, ugh. So like my shirt. It's my combination. See, my Marvel combination shirt. See, so I got Deadpool, Spider-Man, Iron Man, Captain America, Thor, Hawkeye, all in one. I'm such a Marvel nerd. Jinx is like, I think you should get the fan. I don't even know where I have one, to be honest. Hi, Eric. Travis and I had a very short discussion right before this. I wish I would have got a chance to talk to him more, but for some reason he was missing in action all day and he just showed up at the last minute. So Travis, if you have anything earth-shattering you want to say, let me know and I'll get you a link. Marvel rules, yes, it does. Have I talked to the family at all? I've talked, I've messaged them a little bit, but not too much. And I talked to Sandy today, and she's talked to Steve several times. He's okay. He's angry and upset, but nothing that we wouldn't expect. But he's doing okay. And I told him that I will break in there and kick his butt if he tries to give up on me. You are not allowed to give up. So, yeah, I can imagine it's very hard. Okay, well, there's about 70 people, so I think I can get started. Now, okay, first things first. It became very obvious today that my brain is still a mess. One of the reasons it took me so long to read it is because, wow, I still, considering how easy this stuff used to be for me, and even though I already knew everything that was going to be in here, I mean, I literally feel like I knew everything they were saying here. I still kept rereading, and it wasn't comprehending. So the issue that led me to stop doing this is still there. So just bear with me. Also, if I say something that feels like you want to turn me off, just give me a minute. Like, just don't walk out on me. I swear there'll be good things eventually. There's really some things you might not like that I'm going to say though. But that's because it's me, and you know who I am. And that is that I always try to maintain perspective. I don't try to have an emotional reaction, as emotional as it is. It's very emotional. I'm like obviously devastated for Steve, but I've had all day to sit with it. So, if there's details that I'm not remembering, because I have not had a chance to go back and review I don't know, thousands of pages that led up to this decision. So obviously I'm forgetting things. I actually looked things up in my group that I remember that I posted about. And it was like, wow, that post was 3 years ago. And so I tried to brush up on a few things, but I then switched over to doing video, and I didn't have time to watch any of my old videos. I can't stand watching myself as it is. So, oh, do you like my name? Interested member of the public. I do want to say, I don't know if you saw it or not, but in one of the footnotes, I felt like we got a shout out. I thought it was kind of funny, to be honest. I don't know what page it was on. I'll get to it eventually. But yes, it specifically notated something in the footnote because it said because of interested members of the public. So that's my name. Yes, we did get a shout out. I thought that. I shouldn't laugh because it's, but I still thought it was funny. I was like, oh, they actually thought of us. That was so sweet of them. I'll get to it eventually. So now, if you remember, back in April is when Kathleen had filed a motion about the eyewitness coming forward and saying that they saw Bobby and another man pushing the RAV toward the salvage yard. And I had said at the time that I did not know procedurally how they were going to handle it, because essentially, as far as I know, I've never seen this happen before, where a case had been fully briefed. It was already in front of the judges, and all of a sudden there was new information. Procedurally, I didn't know how that was going to work. After about 3 or 4 weeks passed, I told a few people, I said that since it was taking so much time, I thought that there was a good chance they were just going to rule on the entire appeal, and they would address this issue, the eyewitness issue, in that decision. And that's exactly what they ended up doing. That being said, I still was expecting this appeal to come later this summer or early fall. I was thinking more September, October. That's really what I thought. And so I was a little surprised when I saw that it was scheduled for release. I came a little sooner than I thought. After it was released, it is a per curiam opinion. And that means that it's not authored by one specific judge. It's written collectively by the 3-judge panel. No one judge is putting their name to it. And that it can't be used for presidential purposes. It can't be set as precedent. So the first thing I wanted to look at is what 3 judges were on the panel because, I mean, I think we could have figured it out. I knew already, but I just wanted to double check because we knew that Riley and Neubauer would probably be on it. They were on Steve's previous appeals, but I didn't know who the third was going to be. And then Davis was appointed by Tony Evers, and he was the judge that was on it. And then interesting enough, his tenure expires in 3 days, July 31st, because he lost in the election. So he's actually, leaving the Court of Appeals on the 31st. So I think that may have had something to do with why it came out early, because he was the judge that was there while it was in briefing, and they wanted to get it disposed of before he left. So in some ways, that's good. Okay. It obviously didn't go in our favor, but at least I believe that's probably why it came out quicker than we expected. A Sapper cop. It's really not a cop out. That's why I said, you guys don't get mad at me. This is actually, and I said, bear with me. Okay. This is actually probably the most consideration Steve has been given by a Wisconsin court since this started. Okay. They don't write lengthy opinions. That's nothing new. 49 pages is actually a really lengthy opinion for a court of appeals. Go look at other opinions. You're lucky if you get 10 pages out of them. 49 pages is actually pretty long for a court of appeals opinion. Travis, do you want to weigh in on that? That's actually a pretty good size opinion for a court of appeals. It's not a cop out. It's not. I hate to say it. If you go back and watch all of my videos on these specific issues when they came up, it's almost all the same. We knew that 95% of that petition was going to be thrown out on procedural bar. If you didn't know it, you weren't paying attention, because we knew that was going to happen. That was today. Travis brought something up, and I'm like, I filed that in the not surprised department as I read it. All of the testing, all of the scientific testing, we knew that was not going to go anywhere. We just knew it, because there were no conclusions. There were no distinct conclusions. And that was already brought up. I mean, Kathleen was hoping there would be, but there wouldn't. So I guarantee you she was not surprised by that. And neither was I. And I feel fairly confident that Kathleen wasn't surprised about most of this. When people asked me what I thought was going to happen, yeah, it is. It is actually a very detailed opinion. I'm sorry if you guys don't see that, but it is. And if you've read any of the previous opinions in Steve's case, you would probably notice that. It's actually pretty well thought out. And I'll get to what the part is that I think is good in a little bit. Because there is some stuff that's very frustrating, but most of the stuff that is frustrating is appellate procedure. You guys are frustrated with the appellate process. It's not the court itself. It's the process that's been in place since the 1890s. This is the way the process is. And it's extremely unfair to somebody who has been convicted wrongfully and is looking to overturn their conviction. The process is, or the system is broken. And that's where we have an issue. So the court ruled based within the parameters of this broken system. Now, if I'm going to pick one thing that people, even up till 2 days ago, people were still asking me, what do you think? And I kept saying, come on, it's coming out in 2 days. You don't need my opinion. If I'm being honest, I thought everything that was going to happen was going to happen, except I thought there was a chance, at least, that they would rule in for a hearing on the Bones issue under the constitutional argument, under both, more under Greenwald and then Youngblood, because I did believe that there was enough to say that they were potentially exculpatory, and I just did not understand how you could say that it was not done in bad faith without a hearing. So those were the two issues, or that was the one issue with those two components that I thought he had the best chance on. I'm hesitant to say what I really feel because I have not been well. Everybody knows that. I had us take a step back because of how awful some people are on social media, and the stress caused a very awful illness that I've been dealing with for 2 years now. And I'm afraid to say anything that's going to make me a target again. But if you want to know what I'm angry about, and if I see the number drop, that's fine. But you can hate what I'm going to say. But the one thing you can't say about it is that I'm wrong, because I'm not wrong. I hate that we're in this position of procedural bar because we didn't have to be. Steve didn't have to be in this position. Anyone that's in my group knows what I'm going to say. Kathleen never should have dismissed the pro se motion. I will never understand why she did that. I want to cry. I told Sandy today, I said, I just want to cry because I'm so mad. Travis, I'm not going to be that blunt about it, but I mean, I'm not going to say that because I think she's done a lot of wonderful things for Steve, but I'm so mad that she dismissed that pro se petition and filed a new one when everything about the law says you only get one petition and you can only file the original petition and supplements, and that's it. You can't dismiss it and file a second one and not have to deal with the procedural bar. I've been saying this for 4 years, and seeing it be the reason why so much of this was rejected. Okay, I'm sorry. It makes me really mad. It makes me really upset. So when everybody's fuming and upset, I'm like, I'm probably upset with someone different than everybody else is. And I don't want to be like too hard because, like I said, I certainly respect Kathleen and I think that she's amazing and she's helped so many people, but I just don't understand that mistake. I don't. And I'm like sitting here angry. Like, I want that explained to me. I want that explained to me. Why? Because all of those issues that were in, all these issues that have been brought up that have been barred by procedural bar, that wouldn't be the case. That wouldn't be the case if she had just done what she's done with all of these other motions, these supplemental motions, and if she had said, see, I'm getting it right there, Kathleen knows what she's doing, then explain it to me. I'm sick of seeing this. I'm not saying she doesn't know what she's doing, but explain it to me because I'm not wrong. That's what I'm talking about. This is what I say this and everybody acts like I don't know what I'm talking about. I am not wrong. And I don't even know who's saying that because in this petition, when she wanted to add things, she filed a motion with the Court of Appeals and said, can I file an amended petition? Can I file a supplemental petition? If she would have done that on Steve's pro se and said, Steve now has counsel, can we please file an amended petition so that he is properly represented? It would have been allowed. And so, yeah, I'm going to get upset when people get on me. Because I'm not saying she doesn't know what she's doing, but that it was a mistake. It was a mistake, period. Okay? Oh my God, I didn't mean to get this upset about it. But, okay, I'm letting it go at that. Because I'm already going to get like so much like, I don't care. I'm hardly on social media anymore. And this is why my group is like closed. And I only post when there's things going on. Because, you know, like people get upset when I say things they don't like. And I'm sorry, like I said, you cannot like what I'm saying. It doesn't make me wrong. And I'm upset about it. And I'm upset because Steve should be having a hearing right now. That's why I'm upset. And if anybody wants to know whose side I'm on, you know, I'm on Steve's side. I am 100% on Steve's side. So if a lawyer, and I did this with Dean and Jerry too, as many people think they're heroes, they screwed up so much. And when they make a mistake, I'm going to say it. Because Steve deserves that. Okay. Thank you. Thank you to everybody who's being understanding, because I swear to God, I do not sit there and I do not want to judge, you know, what's happening with Kathleen. I don't want to judge what she does because, hello, I'm not an idiot. She's been doing this forever. She has an amazing track record. I acknowledge all of that. But that has always been why it has been so baffling to me to make a mistake that cost him so much. While I'm on it, I'm going to say the one other thing that I'm upset about. And again, I said this back in November of 2017 when this CD issue came up. Kathleen filed, and she filed it under a Brady claim. And I said right away, this isn't a Brady claim. I don't exactly know why she filed it as a Brady claim. And I said right away, to me, this is a clear-cut IAC claim. I don't know if she can win on it, but it is such a much stronger claim on IAC. It was remanded. So when she filed that with the Court of Appeals, they agreed to stay and remand, and it was sent back to the lower court. And then when Kathleen filed the brief, she said at the end of it, something along the lines of, and alternatively, if it's not a Brady claim, then it should be an ineffective assistance of counsel claim. And I looked at my post today and I said, she finally included the IAC claim. Hallelujah. But then I said after that, but she didn't include an argument. It was like a tiny little paragraph that was like, by the way, oh, I'm sorry, ineffective assistance of counsel. I'm sorry. Jinx, I can't believe you of all people had asked that. Ineffective assistance of counsel. Sorry, I do that. And I talk fast, so I'm really sorry, especially when I get upset. I'll try to calm down. And so I was like, oh, but at least she included it. Well, in the opinion today, they said, again, kind of exactly what I just said. They're like, well, actually, this is pretty much more of an IAC claim, AC claim, but you dealt with it summarily. So we can't really rule on it. We can't, evaluate it because you didn't really give us anything. The problem is now that if she brings it up at this point, I think it'll be procedurally barred. So again, that's an issue where the court probably would have maybe ruled in his favor, or at least given him a hearing, and it was left out. And I don't know. Okay, so that's it. That's all the bad stuff I'm saying, and I got it on my system. I'm going to try to stop crying, and I'm really sorry if I made everybody uncomfortable. But hey, I'm the one that's sitting here on camera crying that everybody that hates me is going to make fun of now. So, and I'm telling everybody right now, if anybody makes fun of me or gives me a hard time, don't show me. I don't want to see it. It stresses me out. Just ignorance is bliss. Thank you. So I'm just putting that out there. I'm not on social media much for a reason. Okay, so now let's go through the rest of this. I always tell it like it is. Everybody knows that. I got my anger out. I got my feelings out. So now, and I do, and my heart breaks for Steve. I can't even say Steve's name. Can't even say his name. I'll just start crying again. Okay, so we're going to skip through, most of this, like I said, they were talking about the pro se motion, what was filed in the original petition. We know what all happened with that. That was mainly about the scientific testing and all of that. And they said that essentially, you really didn't come up with any solid conclusions that could actually say that the state, that if different experts had been presented, they would have said the same thing, or they would have come to different conclusions. And you certainly can't say that it would have changed the outcome of the trial. You guys, thank you. Thank you so much. Okay. And I didn't want my glasses to fog up, and then here I am crying. So, okay. I cry when I get angry. Okay. And upset. Angie, okay, Angie, you can't possibly miss my feelings because you're the one that has to deal with them like on a daily basis. Of all people who shouldn't be missing my feelings, it's Angie. Okay, so that was the stuff with, I said, the stuff in the original petition, and then all that testing. Again, it was just that they were drawing conclusions that you couldn't say for sure were going to change anything. Oh, the way that I was going to start this was that based on what some of the questions that I've seen, is that I think a lot of people, and it's been a lot of time. I fully admit I've forgotten a lot because I haven't been studying this stuff regularly, and my brain's stupid right now. Okay, my brain is mush. I don't remember half of what I used to know for sure. But I wanted to remind everybody what the Court of Appeals does, because I know I saw a comment today about somebody saying like, this is just like they're not even addressing the merits of the case. That's not what they do. That's not what the Court of Appeals does. So we need to back up a second and remember what the Court of Appeals does. Okay, it does not retry the case. It does not second guess the jury. It is strictly looking at constitutional or jurisdictional claims. Okay, this is why, again, the process, the procedure to get an appeal or to get a conviction overturned can be very frustrating because you are very limited in scope of what they can look at. To remind people, after a conviction, you have a post-conviction hearing that is held in the trial court, same attorneys, same judge. Okay. If you lose that, and that's to address anything that happened in the trial that you believe was wrong, that was an error, that the judge handled something wrong, like the Denny motion, any of those things, that's when you address that. If you lose that, then you can file what's known as a direct appeal. And that's when you can challenge the verdict. And in the direct appeal is when they brought up the issue of the juror that Boardman, was that his name? Yeah. But Rick Mahler was involved in that, in the appeal, because of the things that happened in the juror room and some of the other issues. But those were handled on direct appeal. Okay, because that's where you can challenge the verdict and basically say, hey, he's not guilty and you screwed up. Once you lose that, you are stuck with what's called collateral review. Okay. And collateral review is reviewing issues that are essentially tangential to the verdict. So you're not saying that you were wrong in saying he was guilty. That is not come into play. Guilt and innocence does not come into play at all on collateral review. If you remember from Brendan's case, the petition for federal writ of habeas corpus is also collateral review. If you remember, they weren't evaluating whether they thought Brendan was guilty or innocent. They were evaluating whether his constitutional rights were violated with that confession. So I lost some people, and hopefully it's not because they all hate me now, but they're evaluating it. They're evaluating errors of law. Okay. The facts presented are judged by the circuit court. That's what Judge S had to look at. She had to look at all those facts that KZ presented, and she had to decide whether those facts added up enough to say that Steve's due process rights were violated. Okay. And she determined no. Okay. We don't agree with her, but she determined no. Now that it goes to the Court of Appeals, the Court of Appeals is not dealing with those facts. It is dealing with issues of law. So it is looking at, did the judge make an error of law when she ruled the way that she did? And it's very important to understand this distinction, because I see people talking about specific facts that they didn't even consider, or they didn't consider it on the merits. There are no merits when it comes to the Court of Appeals. We are specifically talking about whether this judge made an error with regards to interpreting the law. That is what it's looking at. Okay, so hopefully that clears things up, because I was really frustrated with seeing some of the complaints today. I'm like, that's not what the Court of Appeals does. I thought we covered that, but it's been a long time, and I fully understand that it's been so long. We have been bouncing back and forth, well, and see, okay, Jinx, here's the other thing, the narrative. Okay, so here's the other thing that you guys have to understand. We have been looking at documents from pretrial, the original investigation, everything that has come out as a whole. That is not what the court is looking at. The court is looking at the court record. And as much as it kills us, the trial is the official narrative. Okay? It doesn't matter how bullshit that is and how much we know is incorrect about that narrative. That is the narrative in the court record that they have to go by. And again, this is the time when I'm going to say again, this is why it is so hard to overturn a conviction. And Jinx, honestly, that will be considered harmless error. That would be considered harmless error. It would. Because that's not the key point. The key point isn't whose bones were in the barrel. The key point was you can't say that Steve didn't put them there. That's the problem. And that's what they were saying. It's not, and okay, here's the good thing. When people ask me what the next steps are, Kathleen can file a motion for reconsideration where she can correct errors like that. To say like, hey, you guys made a mistake, and you can, to let you know. And I'm telling you, it's not going to make a difference, because as far as from their perspective, it's not so much, like I said, we are stuck on facts because hello, that's what matters. But remember, court facts, legal facts are not the same as truth facts. They're totally different. And it is so hard to separate the two, because in our heads, we have seen enough stuff to say like, that is completely wrong. We know it's wrong. We've seen enough documentation to prove that it's wrong. And yet that is the official record of the court, because once he's found guilty, everything that happened in that courtroom is fact. And this is why, if you can get to the point of getting a new trial, you try to fix all that stuff. So that's a part that it's frustrating. I know you guys read it, but that's actually like I said, it's considered harmless error. And I hate it because to us, it seems like these details are so important, but from their purposes and for what they're evaluating, it's really not. The key point there was that there was nothing saying that it's up to Steve to prove I could not have been the one to put the barrel, to take the barrel and put them in the barrel or pour them out of the barrel. I could not have been the one to do that. That's what Steve needed to prove. And yes, he has to prove it. The burden of proof is completely on him. This is not like the original trial where it was on the, well, should I put quotes that it was on the state to prove that he was guilty? Because it certainly wasn't the case, but technically it's supposed to be on the state. This burden completely switches to Steve. It is up to Steve to absolutely prove that if you're going to try to prove that he was convicted unjustly, it's completely up to him to prove it and to show that there's no way he could have done it. And it's not up to him to find out who did. It's just he has to be able to prove that he didn't. Or at least give enough evidence to prove that no reasonable jury would have found him guilty if they'd had that information. And I will say again, there's a reason why convictions don't get overturned. And this is also the reason why, and I've mentioned it before, why groups like, or organizations like conviction integrity units are so important, because they offer an alternative way for people to get their conviction overturned, not going through this system that was designed to keep people in prison. So it's completely designed to keep people locked up. And they don't make it easy. So I wanted to make sure I clarified all of that so everybody knows exactly what the Court of Appeals was supposed to do, what their job is, okay, and why they talk about sufficiency. They talk about sufficiency of evidence. That's their biggest thing, is because they said you have to really plead something with enough information to leave no doubt in their minds that he most likely didn't do this, and that any reasonable person would see that he didn't do it. And that means that a jury would have possibly had a different verdict. Okay, now I'm going to have to read some of this. They talk again about procedural bar. And Kathleen's most major reasoning against procedural bar was that Steve is indigent. He didn't have the resources. And I told you guys then that it sucks, but that has never been allowed as a reason. It should be. It really should be. But that has never been a sufficient reason to be able to file a successive petition. And it's ridiculous because they say flat out, you don't have the resources. They did allow one argument about him not having access to investigators or something like that. But again, it wasn't enough, they said, to change anything. So yeah, because here's they're talking about the sufficient reason. I wish I had somebody else that could like entertain you guys while I'm scrolling through this. Talk amongst yourselves, please. Let's see. Tracy, talk about finality. Yeah, and this is the thing that drives people crazy because it seems so unfair. But the reason you're only allowed to file one petition is because they believe in having finality. You cannot have somebody filing an endless string of frivolous petitions, bogging the court down. And when you think about it from a logical sense, it's, you understand it. Okay, yes, you can't have somebody just any, Tom, Dick, or Harry filing just an endless string of petitions because they don't want to be in prison. It's just that what happens when there's somebody that is actually innocent? And that's where there is nothing to account for that in our system. Not in Wisconsin anyway. Again, if you have like a conviction integrity unit, that can certainly help. EDPA is a federal thing. So that is definitely not. Oh, I think you said something about federal. Let me see. It won't go the habeas route. Kathleen won't take this federal to the habeas. She already said she wouldn't. So I'd be surprised if she did. Steve won't win on federal review at all. Because again, they have to say that the state courts, the Court of Appeals decision was so unreasonable that no other court would see it the same way. And I think they're like 95% of it at least is completely valid. So you would not win on that. But she also said that she would rather file successive state petitions than ever go the federal route for Steve's case. Because it's so hard to win, as we found out in Brendan. I mean, look at Brendan's case. If he couldn't win, Steve was never going to win. Travis is saying this requirement promotes finality once the defendant has been convicted and sentenced, minimizes time-consuming post-conviction hearings. And it sounds so callous, again, when you look at it through the lens of wrongful conviction. But when you look through the lens of rightful conviction, you understand why they have to have that. But it always just sounds bad. Makes it sound like they don't care. Because what is happening is that when you have a procedural bar issue, you're basically saying it doesn't matter that your claim is valid. It doesn't matter that your constitutional rights were violated. You didn't bring it up in time. That's what they're saying. And so it's not that you can't violate someone's constitutional rights. You just have to make sure you do it after they've already filed a collateral review of their conviction. And it's wrong. And then Sapcop's saying, wait, this means that it's over. No, not necessarily. Be more positive than that. There are a couple other things she can do. So just hold on to that. Now, EDPA needs to go away. Yeah, EDPA is problematic. That was problematic. We learned that in Brendan's case, and that's not going away anytime soon because the states love it. So I'm going to skip all this part about why it's like, it's procedurally barred because we already know. We have talked about this so much. I always tell people, if you don't remember, go back through my group, go back through the videos on YouTube. They're all on there somewhere talking about this stuff. Yeah, a lot of it was spent talking about that. That was now here we're talking about Brady violations. Oh, okay. So now this is an important piece right here. And Fen, are you still here? I think, was it you? I can't remember who it was. Yeah, Fen asked me about the bones issue, and we talked about, and she said, well, that's it. And I'm like, yeah, it's dead now. Okay, I want to caveat that. When I say an issue's dead, that means as is. Obviously, if newly discovered evidence come up, it can always be resurrected. Susan, I haven't really covered a whole lot with the bones. I just said that that was the one issue I thought that Steve might be granted a hearing on, was the bones issue. No, Becca, this won't affect Brendan's case at all. Well, technically, the only reason it would affect Brendan's case was if Steve's attorney, if Brendan's attorneys were hoping something in Steve's petition would be granted a hearing that they could also use in Brendan's case. But there probably wasn't much there that they were thinking they could use, I'm thinking. But they probably were most likely waiting. So I can't say it won't affect it. I mean, from his attorney standpoint, it might change something that they were waiting for, or that there might be a ruling in here that they were looking at. But you can't really use Steve's petition as a benchmark because Brendan has never filed a petition in state court. Brendan would not be procedurally barred from presenting a lot of these issues, which is why Brendan's attorneys are waiting. They're not going to file a petition until they're ready because they don't ever want to come up against this procedural bar issue. So that's why they, want to be careful about what they present because they don't want to miss anything. So, I mean, it was smart to wait to see what was going to happen with Steve's case, just in case. Okay, so here's one thing. They talked about some of these Brady violations, and they're dismissing them because, again, they're saying that, trying to look at which one I'm looking at here. Specifically, they're talking about the flyover video. And I remember them saying that the only supporting evidence that this would have changed the outcome, or that there was other video, was the length of the flyover. It was 4 hours. It was a 3-minute video. And other than that, and there was, because he's saying that the investigators concealed the knowledge of another flyover video, whatever. And because of the neighbor that saw a car going over, or being the SUV being driven through, and because of the length of the flyover video, they were saying that was not sufficient enough to prove that they left anything out, that they didn't hand over anything. Well, as everybody knows, since then, we do know there's another video. We know in an email that was received via FOIA request that Fallon most definitely put in an email that there's another video. So this is what I was talking about when I was saying that it's good that this is actually a very thorough opinion and it's very well thought out, because there are times when I feel like it's essentially a roadmap for KZ on what she needs to do. And one of them is, okay, well, there's nothing showing that there's another flyover video other than Steve just saying so because he thinks that they shouldn't be up there for 4 hours and they only have 3 minutes of video. Now there is something showing that there is another video and it was being withheld. So that's where I'm saying that there are things that are actually very positive here, because they flat out said, this is what you need. You need something else showing it. And hello, wow, look at that. We've got an email. And you can't, I don't see how that can be procedurally barred because it was just discovered. It doesn't matter that email was written a long time ago, because it was received via FOIA request. It was not, it's between the lawyers. There's no reason to think that it should have been found earlier. It certainly shouldn't have been found by Steve when he filed a pro se petition. So, so that's something. Again, I'm not going to say he's going to win on it because we're not far enough in the process to say that. But that gives right there, that's the number one thing that Kathleen can put in a new petition. Okay, that she has. Is that they concealed a flyover video. Because he's saying he alleges that the state withheld an unedited video of flyover footage of Avery's property. And they only released to him an edited 3-minute version. And he, let me see, what does it say? Yeah, so they're just talking about the video, the other evidence, the Brady violations. Because I know Kathleen tried to argue Wierski, and that was the case that the Wisconsin case that put more of the burden onto prosecutors to turn over Brady material, as opposed to making the lawyers and the investigators be so responsible, like having them to carry the burden of trying to find this information, that it should be on the state to be more forthcoming when releasing Brady material. And that just unfortunately does not apply in this part. It just really doesn't. And then they talk about the voicemail. Okay, now here's another issue that I saw people talking about. The voicemail that was left at the zippers, and they're saying that it proved that she might have went there to begin with. Okay, this is when I talk about, again, when I talk about the official narrative from the trial. Right away, they said, well, the testimony in the trial proved that she went to the Avery's last. So that's why that's just thrown out right away. Because again, it doesn't matter what was put in a previous report prior to trial. It's what came out at trial. And at trial, it was very clearly established what the timeline was. Kathleen says she knows TH's call to Dassey House was returned. Oh, can she use that? Trying to think of what context she could. Okay. There is an opening where she talks about the computer and talks about potential Denny material that could be used against Bobby. And they mention that, I'm kind of combining things here, that's something that could be used if it wasn't already put in there. But the other aspect of that was that that's also where that eyewitness is going to come in, because they specifically, again, mentioned, like, again, they essentially just flat out told Kathleen, if you want to file this in another petition, that would be possibly a direct connection to the crime that would fulfill that Denny requirement that you're missing. Because they said that now the computer stuff shows that there could possibly be motive, but they're still missing direct connection. But they're like, but hey, this eyewitness stuff you brought up, hey, there's a direct connection for you. So again, as frustrating as you think this opinion was, they actually like flat out were like, nudge, nudge, you know, this is what you're going to add to possibly, and when you call into question the Denny motion, it's a big deal, because if you can establish that Bobby should have been a Denny suspect, you have to throw out the whole trial, because that means that the trial was not fair because a legitimate suspect was left out. So even though the Denny issue is prior to the actual trial, it was hugely influential, or the lack of it was hugely influential, or would have been influential had it been included, I should say. Yeah, well, yeah, Linda. I mean, that's exactly it. I mean, that's the thing. Steve is guilty. We might not say Steve's guilty. We not think he's guilty, but in the eyes of the law, Steve is guilty as sin. He is guilty. He killed her. he didn't burn the body. He didn't mutilate the corpse. He didn't rape her, because that's not what he was convicted of, but he killed her. And everything that's in that narrative is the truth from a legal perspective. And that's what the courts go by. And it's frustrating because obviously we don't see it that way. That is not our truth. Those are not our facts. But but again, from a legal standpoint, that's how it works. And reasonable doubt, yeah, that goes out the window after the trial's done. There's no more reasonable doubt. This is now, you have to present concrete evidence that you were wronged, and it's not even just evidence. It has to lead to I can't even talk. Sorry, guys. I still get so tongue-tied. It has to lead to concrete evidence showing that it could have been, there could have been a different outcome in the trial. And so it's not just evidence that might lend you to think, or lead you to think that he might be innocent. It has to be enough to say that a reasonable jury could have looked at this whole case differently and given a different verdict. That is a high burden for anyone to have to hit, especially when you're behind bars. It's a moot point. Okay, let me see what else is here. So that's what the thing with the voicemail is, that, do I know how Steve took news? He was upset. Yeah, Sandy talked to him like 3-4 times. He was angry and he was upset. He calmed down a little bit later though. So he's calmer now. Which totally, look at how angry all of us are. And then the flyover version. Okay, we talked about that. Now they're talking about the newly discovered evidence. So this is when they're going into a lot of the scientific stuff. And they say that the evidence is, and again, so much of it is that you have this evidence, you have this interesting facts, but you have to be able to show how, it has to provide more than just a possibility that maybe he didn't do this. You need more than that. And that's where, it's kind of running into a brick wall in here. And that's what they're saying. They're like, it's not just that, we're not saying that these things aren't interesting or that, it might not be an issue. It's just that you're not giving us enough to say that, hey, it's not undermining confidence in the verdict as far as what they're saying. Oh, that's nice. You sent your first letter to Steve. He'll appreciate that. And let's see. Talking about ineffective assistance of counsel. You see, when I read this, I was already like, I'm going to forget it all. And I hate trying to read it because I can't read in the moment and like think. Yeah, this is all just about the scientific testing again. About some of the arguments. And again, I saw Kathleen's tweet. She's not shocked. She's not shocked by a lot of this. She's not surprised by a lot of it. Even Kathleen changed her approach to things many times throughout the course of this appeal based on other evidence that she had that came up. And they talked about the blood and, and they said that it's not enough to say that it looks like it possibly could have been planted. You have to give more information. They said that's the type of thing you present in a trial. All of this stuff that Kathleen has, and she knows this, is what she needs for a trial. If she has a trial, if they even try to, if they overturn it and they try to try Steve again, she can bury them because this is the type of stuff that should have been in a trial that would have completely just made a convoluted mess out of the state's case. Because you could have presented then all of these experiments. You could have shown them to a jury and let them evaluate exactly like how much weight they were going to give to all of these experiments. An experiment is just that. No matter what, it's not going to take, it's not going to take the place of, you can't say that that's actually what happened. You can only say that this is our theory. And theories are not going to get him out of prison. They're just not. That is very true, Stacy. It is not a court of justice. It is a court of law. And sometimes the law is annoying. I accidentally did not mean to do that. Okay. The motion for relief for the order. Okay. This is what I look back at because I remember when she filed this motion for reconsideration that she filed, I had said at the time, you can't do that because remember Kathleen was planning on filing. She was still investigating. She was planning on including more in the case or in her petition. And then the judge ruled, and she didn't rule prematurely, even though I don't care how many times Kathleen says it. It was not ruled on prematurely. Okay, this case, it was ruled on at a reasonable time, but they did not notify the judge that they had an agreement coming up. That they had an agreement they were working on. So she ruled. So Kathleen tried to file this motion for reconsideration, and in it, she put all this new evidence. Okay, you can't do that. There are certain situations where you can present something new in a motion for reconsideration. So what the court did here is they actually listed the things that they could consider, which were the phone call with Barb, and I think that was in that motion for reconsideration. I believe that was part of it. If I'm screwing it up, whatever, close enough. But they talked about those things. And again, all those issues, that phone call with Scott and Barb. And again, you could predict where that was going to go. Them threatening Steve, Scott yelling at Steve, and him saying, well, Bobby said this. It's hearsay. That was never going to go anywhere. Again, it just adds fuel to the fire for us to get pissed off and know that there's more to the story. But from a legal sense, so Barb said she talked to Bobby, and Bobby said that she left. That has no legal standing whatsoever, especially when you see it in a Facebook post. So that was never going to go anywhere. So again, that was filed under the not surprised category. But what they did then in the footnote is they actually listed the other issues that were brought up in that motion for reconsideration. And they said, these are all things that can be filed in a successive petition. Okay, now here's the problem with that. They listed, I think, 7 things. Denny claims, Brady claims, everything. And they said, those all need to be filed in a successive petition. Problem is they're going to be procedurally barred. They're going to be, because the question will be, why weren't they presented in this petition? And she should have, if anything, she should have filed another motion to supplement the original petition. She never did after this motion for reconsideration. So, but this is what she's going to be allowed. This is when it said at the end, if you read the document, it said at the end that motion number 6 and portions of motion number 3 can be put in a successive petition, but they can't guarantee it won't be procedurally barred. Well, this is the part that's going to be procedurally barred. Maybe not all of it, but I think so. I just don't see how it won't be, because she already presented it, and there's nothing saying that she shouldn't have been able to put it in an actual motion to be part of the petition. So there's that. They mentioned, this is the one thing that I always kind of was like, and I knew this wasn't going to change anything, because just like anything, I'll say, I know when something is considered harmless error. And it was in the original decision by Judge S when she said that, she needed to file a motion for IAC claim against post-conviction counsel is in the trial court, but appellate counsel is in the Court of Appeals. And so Judge S told Kathleen, you're filing in the wrong place. And then I was like, no, she's not. You're stupid. So, and the judge was wrong. And they say here that the judge was wrong. But again, the circuit court's error was harmless. She was just stupid. Yeah, she's the judge. Where is the next part? We're getting to the Facebook post and the phone call. Yeah, they're just saying that it did not erroneously exercise its discretion when it ruled on this motion. It does talk about the day planner. And again, it's saying that they just say that the evidentiary basis for some of these claims is lacking. For example, one claim is based on Avery's assertion that Ryan Hilligus later possessed a day planner that was in her car on the day of her death. The evidence Avery submits, however, does not and cannot reasonably be construed to support this conclusion. Moreover, other claims do not appear on their face to entitle Avery to a hearing. So there, they didn't say a whole lot about it. And it says here that, for example, one claim, as far as we can tell, is based on a recreation of what Halbach's movements would have been had she driven away from Avery's property on the date of her death. But again, they're saying, well, you can't prove that she'd ever left that property. So it's a hypothetical scenario. He's talking about when she said that she left the property and Bobby followed her and all that stuff. Yeah. They're saying like and they're right. It is a theory. That is all it is. I even don't like that theory. So, so you're certainly not going to get a hearing on that. You love that I call her Judge S. Everybody else called her Judge Flowers or Judge Suck at This. Or technically, like I said, I believe it's Sakevich, but that's just too many words, too many syllables. Judge S. Everybody keeps saying, what's next? Look, I just want to get through this first. I'll get to that. And they bring up the CD issue. And I already talked about this. This was never a Brady claim. I did an entire video on it while I sat there and said, like, why is she filing this of a Brady claim? They fully admit that that the attorneys were given the complete information. They just didn't take the initiative to find the software to open it. That was it. That's on them. That is not on the state at all. And they talk about, they briefly mentioned the whole thing about how it was misrepresented, that that Kratz said that it didn't have any evidentiary value. And again, that's not on Kratz. He's an ass. We know that. That is totally on the defense attorneys. Like, why would you ever believe a word that man says? Paul, are there decisions? Yeah, Paul, did you just show up? Did you just show up, Paul? Yeah, I mentioned him, but I'll mention him again. Or I as I came across them, I mentioned it, but I'll mention him again when we're going through there. Rhonda won't say what you call her. I know everybody have lots of names. Sorry, if somebody asked a question and I missed it. I just saw somebody saying that. Hold on, I don't see the question. Oh, Travis. Okay, Travis, you got it under control. You don't need me. Yeah, again, this is not a fact-finding court. They are not dealing in facts in this court. They are dealing with errors in law. Okay, Travis has got the comments. You don't need me for that. So yeah, so the CD issue, and then I want to get to where they talk about the ineffective assistance. I need to take a drink though. Ugh, it's so gross. Of course, my straw just fell. Hopefully, I won't keep doing that. I hate this part where I'm just sitting here, but okay. So here's where it says that in the July 2018 motion, Avery does indeed argue that trial counsel was ineffective for failing to forensically examine the 7 DVDs prior to trial. Yes, that should have been the main claim from the get-go. We're past that, though. Not bringing it up again. He does so summarily, however, and in a manner that leaves us unable to meaningfully analyze this claim. And again, as much as you might hate it, they're not wrong. And I pointed that out at the time. I don't understand why she did it that way. And it says regarding potential. So this is Paul. This is like part of what you were just asking about. This is something that can be used, hopefully, in the future going forward. So they're talking specifically about the Denny motion. And it says regarding potential use of this evidence in his Denny motion, Avery does not address the prejudice prong of the Strickland test, which in our view encompasses at least 2 key inquiries. He would have to provide that there was evidence directly connecting Dassey to the crime. That's one of them, okay? And a motive. So what they're saying is that even though this CD could prove motive, they don't have direct connection. But then at the end of the motion, or at the opinion, at the end of it, they mention this again, and they say that the eyewitness testimony could provide the evidentiary support necessary to satisfy that prong of Denny, of the direct connection to the crime. Because if he's pushing her RAV or a RAV onto the yard the morning that it was found, prior to it being found, he's pushing it down that road in the dark. The connection to her car is considered a connection to the crime. When you say direct connection to the crime, you're talking about anything involving the circumstance of the crime. That means a connection to her, a connection to her car, a connection to where she was, any of that stuff. And not a connection of she was there and I was there at the same time, but I left and she was still there. That is not enough of a connection. So that's where I say that there is some good news there, is that they flat out tell Kathleen at the end of this that, remember when we said that you didn't satisfy that direct connection prong? Well, this eyewitness stuff might satisfy that. And you can file that in another petition. Because it says that Dassey possibly possessed violent pornographic images might have conceivably satisfied motive, but is insufficient of itself to allow admission of third-party liability evidence because you're not satisfying all three prongs and you're missing the direct connection prong. So, and again, if you can get them to agree, the court to rule that the court was wrong in not allowing Bobby to be presented as a third-party suspect, you have to throw the verdict out, or the conviction out. You have to throw it out. They do mention that there's times when Avery's arguments wholly stray from the facts, and that there's misrepresentations in certain things. And this is where we got the shout out. So it says that Avery this is in the footnote on page 41, if you want to know what I'm talking about, that Avery misrepresented the facts is immaterial to deciding his Brady and ineffective assistance claims. We point them out because of the high profile nature of this case, the greater possibility that interested members of the public will read the briefing and motions, and the resulting need where misrepresentations are particularly egregious to note where Avery's arguments wholly stray from the facts. So that is the Court of Appeals kind of putting us in our place. So hence my name as an interested member of the public. That's a personal shout out to us. So they're basically saying, we're putting this in there for you guys because you're going to be complaining about this opinion. It's exactly what they're saying. I actually thought it was funny. But, you know. And then it says, we are not addressing Avery's most recent filing to this court, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new 97406 motion, and that motion would need to survive both Escalana, which is the standard for a procedural bar, and be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of this. That's what they're saying. They're just basically telling you that's what you can do. So again, you know, they're kind of telling her what she needs to do. And this is exactly why when Kathleen wrote her tweet, she was like, thank you for the, whatever she said, the thorough review or whatever, because she knows too. She's like, they're just essentially telling me what I need to do right there. So, and that's why there's reason to hope, because there's certain things that they're flat out saying, or they're not saying they're outrageous. They're not ridiculous. They're saying you need to present them in a different way, in a different petition, at a different time. So overall, I think that this was more well thought out than anything else Steve has been given. And then they talk about, let's see, what's the next supplemental motion? We're to March 2019. Oh, is this the bones? Yeah, this is the bones issue. Okay. So the most important thing here, and I honestly, this was discussed so much. I know I discussed this so much in my own group and in videos. I can't remember where I stood on certain things. I fully admit it. Thank you, Julie. She's posted a link to the tweet since I can't remember anything. One thing that we talked a lot about at that time was the state statute on preservation. Okay. I remember talking about it, and I can't remember at the time if I said anything about this or if it escaped my attention, because I know that Kathleen brought up both the state statute and she brought up the constitutional issue. So I do remember that she was saying that on this bones issue, it's either a violation of state statute or it's a constitutional violation. Pick or choose. And we did go through what would be involved in both of those things. Now, I said it didn't violate the state statute because the state statute was very clear. Nobody liked that, but I was like, read it. Read it. you know, there were certain things, but turns out it doesn't matter. And that's what they're saying at the top of page 43. They're saying that Kathleen is basically saying that the state violated, number one, a circuit court order, which was ridiculous. I never understood why she put that in there, because she said that that court order from the original judge said something that it didn't say. So we're just going to forget about that. And then two, it says Wisconsin statute 968205 requiring the state to preserve certain biological material evidence, blah, blah, blah. And three, Avery's constitutional rights. And then it says, as Wisconsin statute 97406 motion may raise only jurisdictional or constitutional claims, we consider only the third argument. So the state statute on preservation doesn't come into play at all, because as I said, they only can, on collateral review, you can only review constitutional claims. So this issue of the bones has to fall under the Constitution, which is covered by case law. And that's where Arizona versus Youngblood, State versus Greenwald, and then they bring up State versus Parker briefly in here, and I'll get to that in a second, because that's what I talked about. I talked about Parker when I did my video on this. So that's why that state statute, you can talk about it all you want, but it doesn't apply here. So the two issues under Youngblood. Now, first of all, okay, one of the issues under Youngblood is that Youngblood specifically dealt with pretrial evidence. Okay. And that was a question that was brought up. And that's why Parker comes up. And that's why I talked about it. And they mention it in the footnote. They say, we recognize that Parker somewhat summarily states, we see no reason why this line of cases addressing the pretrial destruction of evidence should not apply to the situation at hand. So there was a situation where they were saying, well, Arizona versus Youngblood does specifically deal with pretrial destruction of evidence. But in Parker, they're saying that's not necessarily always going to be the issue. But in Parker, it was specifically talking about issue that was, or evidence that was destroyed. Oh my God, destroyed. Evidence that was destroyed post-trial, but pre-direct appeal. Nothing that it goes on this long to collateral review. And that's why the court is essentially saying at this point, nobody had any reason to believe there was anything left that had any potentially exculpatory value. And that was the one part of this that I was disappointed in, because I do believe that I thought that if Steve was going to be granted a hearing, it would be on the second part of Youngblood. And that was that it was potentially exculpatory and they acted in bad faith when they destroyed it. And the reason why I thought that he would get a hearing on that is because I really didn't understand how they could say that it was not done in bad faith without having a hearing. Like, how could you determine what their mindset was without asking them? That was how I felt about it. Why do my lips look so funny? It's driving me crazy. Anyway. Yeah, that's what my Travis is saying. Like, how would they know what the intent was? And that's what I thought. If there was one thing that was going to get a hearing, it was going to be that. It's like, you can't say they didn't get rid of them in bad faith when you don't even ask them why they got rid of it. Kathy, this is why I love you. So I've always said that it is not apparently exculpatory. But I always thought it was potentially exculpatory. And I have to get to where their reasoning is. And this is the part I was disappointed in. I had to wait till I got all the way to the end before I was like, okay, no, I'm pissed off at this opinion. I was pissed off anyway, because I think he deserved a hearing. But it's just like, I couldn't argue with a lot of the reasoning up until this point. Avery cannot show bad faith, meaning the officers were aware of the potentially exculpatory value or usefulness of the evidence they failed to preserve. So they're saying that there's no way that the officer, especially at this late in the game, when you get to collateral review, would have any reason to think that it was potentially exculpatory. And the one thing people always argued, and I told you at the time, it didn't matter, is people kept saying, well, it implies that they were Teresa's bones. You don't give them back to the family unless you're implying that they're bones. Implications mean nothing in a court of law. You can sit there and say it makes no sense all day long that they would give bones back to the family that were bird bones. Like that, if they would only give bones back if they knew they were human. It doesn't matter. That's not shown in the record. And what's in the record is Leslie Eisenberg saying that she couldn't definitively say that they were human. So you can sit there and say, why would they give her non-human bones, if it wasn't Teresa, and they don't care? That's not part of the record. The record is saying that they were non-human or potentially non-human. So they were basically, as long as they were not said to be human in the trial, it doesn't matter what all that paperwork said. It didn't matter what it said in the ledger. What was in the trial, and as part of the official record, is the forensic anthropologist saying that they were most likely not human. Or she didn't think they were human, or she didn't know if they were human, but she didn't, there was nothing definitive. And that's why. And it's very frustrating because it seems ridiculous to us. Here, Stacy, yeah, the deck was stacked from the start. Exactly. I mean, like I said, the system is not designed for people to get out of prison. It's not. I know we hear about exonerations almost every day, it seems like, but that is still out of the, maybe 200,000 plus wrongfully convicted people in this country right now. And so it's very easy to lose hope because, it's, and it doesn't matter how good of an attorney you have. You have the best attorney in the world. And if you can't find the information, the smoking gun, as they say, you're not going to find it. There's just nothing you can do about it. So that's essentially what they're saying. The state statute doesn't apply. And the fact that since the actual court testimony doesn't say that they were Teresa's, there's no reason that they should have thought they were exculpatory. And I can actually understand their reasoning. And that's what kills me, is that I can understand it, but I just hate it because it's not logical. I hate when things are illogical. And he also said, they said it's in the footnote, they say that Avery suggests that the state also acted in bad faith during the post-conviction process by actively misleading them about whether it still possessed the bone fragments. But the point at which you're supposed to measure bad faith is at the point of their destruction. So when they got rid of the bones, that's where it doesn't matter if they acted in bad faith about letting him think they were still there. That doesn't matter. So. And then, okay, so now we get to the current one. We said, now this is a stay and remand saying that they have a new eyewitness, Thomas Sawinski. We all know the story. I don't think I need to rehash all of that. And then and I'm just going to read all this because this is exactly what I thought it was. And so again, this is actually perfectly reasoned logic and it makes sense. They said Avery's latest motion arrived while our decision on his appeal was forthcoming. It would be an inefficient use of court resources to now and once again delay this appeal's resolution. We appreciate that Avery likely wishes us to consider this new Brady claim in the context of claims previously raised, but we must weigh that implicit consideration against those discussed above. Simply put, Avery's appeal cannot continue indefinitely. Accordingly, this decision operates as an order denying the motion to stay in remand. If Avery wishes to raise this claim, he must file a new 97406 motion with the circuit court. Pursuant to Escalona, procedural bar, Avery will need to demonstrate why he could not have previously raised this claim, including in his June 2017 motion, before the merits can be reached. And again, that shouldn't be a problem because we all know this just came to light in November or whenever it did. April. Why did I say November? April. So hopefully that will not fall under procedural bar, but she can file that. We know that she can file so Paul, this is what the answer to your question. So she can file this new claim about the eyewitness. She can refile the claims about the flyover video, this time including that email proving that there was another copy or there was a longer version that was withheld. So she can file that because even though that claim was decided, there is new evidence regarding that claim. So that she can present. She can present the stuff that was in the motion for reconsideration that they said that was improperly filed, but that's going to be procedurally barred. And then she can file the Denny claim again using this eyewitness as a direct connection to the crime to try to establish that Bobby Dassey should have been a third party suspect in the original trial. I think that about covers it. Okay, I'm going to read this part just because it's the conclusion. Avery raises a variety of alternative theories about who killed Halbach and how, but as the state correctly notes, the 97406 motion is not a vehicle to retry a case to a jury, and it's not. A criminal defendant is constitutionally entitled as a right to a jury trial, and if convicted, a direct appeal. If he or she later seeks to collaterally attack the conviction on constitutional or jurisdictional grounds, a 97406 motion is appropriate. The key to any 97406 motion are sufficient non-conclusory showings, both as to why the issue was not raised in an earlier post-conviction proceeding and why the claim has facial merit. These requirements are not optional and cannot be met through broad conclusions or by misstating evidence. We express no opinion about who committed this crime. The jury has decided this question, and our review is confined to whether the claims before us entitle Avery to an evidentiary hearing. We conclude that the circuit court did not erroneously exercise its discretion in denying hearings. And that says on which motions. Motions 1, 4, and 5, in not vacating its order on motion 1, and in not reconsidering its rulings on motion 1. As for motion 6 and the portion of motion 3, that's the most recent motion and the motion for reconsideration, raising new claims, we leave open the possibility that Avery may raise these claims in a new 97406 motion. We remind Avery, however, that he will need to overcome the procedural bar on these claims, which includes providing sufficient reason for not raising them in his June 2017 motion. It says, moreover, Avery will need to satisfy the previously discussed specificity requirements before such claims may proceed to a hearing. So there you go. Now, the good news is, let's see. Okay. When she files a new 97406, she can get a new judge. That's the number one thing. We can definitely get a new judge at this point. That's the first step. She can file a motion for reconsideration with the Court of Appeals. A very slim chance of ever that going anywhere. But if she wishes to address some of the factual errors that they put in this opinion, she can do that at that point. She can opt to file a petition to the Wisconsin State Supreme Court. I personally don't think that's going to get her anywhere. I really don't think that there's any matter of law that needs to be settled on that would make them want to take on this case. Outside chance would be maybe on the preservation issue, but I just don't think that they would. So that means she can either file a petition at the federal level, which we already discussed that she will not do. She said she would not do it in MAM 2. She said she would not pursue a federal writ of habeas corpus. Or she can file another state 97406 post-conviction petition, and that's what she's going to do. When she's going to do it, I have no idea. Now, just because we have to, essentially we're starting over. Just because we're starting over doesn't mean it's going to take 4 years to do this again. Remember how many times it went back and forth between courts and everything like that. Hopefully she will file this new petition relatively soon. Hopefully if she has anything else, she's ready to present that. And by soon, I mean with, maybe by the end of the year, hopefully. I think she has no choice but to file appeal. Do you mean to present, to petition to the Supreme Court on that issue? Yeah, that's the only one I can see. I don't know where else you can. There's no other matter of law that might be incorrect. Linda, I'm not even sure what you mean. Nothing she's stacked in this motion can be used in a new motion. I'm not sure what you mean by that. Whatever, I'm not sure what you mean, but what I just all listed are the things she can put in a new motion, and then any other new additional evidence. It has to be newly discovered evidence. And again, when you talk about newly discovered evidence, that means it has to be something that could not have been found through due diligence prior to 2017. Now it's moved up. So now we're talking about a time frame of which since Kathleen's been on board. So it has to be truly new. It has to come to Kathleen's attention after that point. Maybe somebody can run for governor. I told everybody. I'm just saying. Everybody was all excited when we got Evers, and I was like, okay. I never got excited about there being a new governor because I knew he wouldn't do anything either. So do we have any other questions? least I only cried during that one part. And thanks everybody for joining me. I don't know what else to say. Like I said, I'm very disappointed that Steve got another denial. Obviously, most of it didn't surprise me. Staffer cops, I don't see a lot of hope here. Okay, real talk. It was always a long shot. This case has never not been a long shot. This makes it even a longer shot. But almost all cases of convictions are, you can't, the odds are never going to be in Steve's favor, ever. I mean, they're just not. That's not how this works. When you're trying to overturn a wrongful conviction, the odds are always going to be against you, severely so. But as long as you have something, as long as you always have something to keep it alive, to keep it in the public eye, to keep it moving forward, to keep trying, there's hope. If she had absolutely nothing else and there was a flat out denial with no hope of even another petition, I would be feeling a lot worse right now. And I think it's also very important for Steve to keep hope. And so those of you that write him, don't ever make it sound hopeless, because he's doing that enough on his own. So it's very important to keep hope. So I'm not going to sit here and say there's no hope, because there is. And there were definitely legitimate things in here that are promising. Until they're more fully fleshed out, until we actually see them presented to the court with all of the evidence that the supporting evidence, Kathleen is going to start doing more investigation. They told her in here some of the things that you need more evidence. This was not, you did not give us sufficient evidence. So she's going to go look for more stuff. Trust me. Oh, sorry. What are you guys asking? I keep missing you guys. I don't know why. Okay. Sue's question: in the future, could Steve claim ineffective? Sounds like well, I'm not going to say I told this to Steve a long time ago, but I may or may not have done that. But as long as Kathleen's the attorney, that's never going to happen. Can the bones issue be readdressed? Again, my answer is generally no, but that is always, there's always an asterisk by that. That means that if there's newly discovered evidence with regards to the bones, if some new evidence comes to light, well, then yes, it can be readdressed. But for the most part, no, that issue's dead. Oh, so is this thing, could he fire KZ and get a new lawyer and file on it? Yeah, Steve's never going to fire KZ, that's for sure. She works for free, and it's just, let's put it this way: if I wouldn't put this idea in Steve's head, because Steve will do stupid stuff if given the opportunity. This is a really tough one, because I do believe he absolutely does have a claim. Whether he'd win on it would be very difficult, just like anything else. But there is a legitimate claim there, for sure. That's all I'm going to say. And, am I going to get, but again, if people want to hate on me, prove that I'm wrong. Tell me what in those statements that I said, where I said that she should have amended that petition instead of dismissing it. If you want to tell me where I'm wrong in that, that's fine. But otherwise, you got no reason to hate on me for it. But people will. And I'm just asking everybody, don't tell me about it. I don't want to know, because stress is bad for me. And I'm still dealing with this illness, and stress does exacerbate it. So people are being jerks to me. I don't want to know about it. And I'm just not on social media enough to care. Jen, I'm a little confused. Earlier, I thought that because KZ dismissed and refiled the 976 was an issue, but just now it sounds like she can file again. Okay, this is why it's an issue, is that when you file your first 97406, you can bring up all of the constitutional issues that you think happened throughout your case, whether it be the investigation, the trial, whatever, need to be brought up in one motion. You're supposed to get one shot at this. Okay. You can supplement it. It even says that in the statute. It has to be in a supplemental motion, an amended motion, but essentially all one motion. Once you have that 197406, okay, and you lose on it or it's dismissed and you try to file a successive petition, you cannot raise anything that you should have raised or could have raised in that original petition. If you don't raise something in your first petition, it is considered waived. It's considered you cannot bring it up. And again, it's hard to wrap your head around because it's literally saying that if you find out your constitutional rights were violated later, it's like too bad. You know, it's like they can violate your rights as long as they do it at the right time. It's basically what it is, or you don't find out about it in time. That's essentially what the law is saying, and that's why it's very frustrating. So you can file successive petitions, but you have to give really good reasons as to why it couldn't be brought up earlier. And that is newly discovered evidence has to be truly newly discovered. And not only that, but you have to prove that no amount of due diligence on your part was going to find it earlier. That's the hardest part. It's not just that it came to you at a certain time. You have to prove that there's no way you could have gotten it earlier. And that's why Kathleen was trying to argue, well, how could Steve find out these things? He's in prison. He doesn't even have access to his entire case file. And as illogical and as frustrating as that is, that has never been a sufficient reason to overcome procedural bar. There, I mean, it's the most, straightforward argument. Like, how can you do these things from a prison cell? And yet they have never allowed that as a sufficient argument. And there are a lot of even judges. If everybody remembers, before Brendan's case, Judge Posner from the Seventh Circuit, he actually left the bench prior to Brendan's en banc hearing because of the fact that he wanted to do more lobby work for indigent prisoners filing pro se motions because of this type of issue. Okay, I hope somebody's saying it's helpful. Thank you. Okay, if there's any more questions or someone else point me to questions that I might have missed, because if I'm talking, I will miss them. I should have somebody else on here just to point out questions. Throw them on the screen for me. Let me just scroll through here. She's not working for free. Well, you know what I mean, though. Yeah, Casey's been on this case too long. She knows it better than anybody. And I want to be really, like I said, I'm not, I don't live to bash KZ. It is not what I want to do. But when I see something that is that costs Steve a lot, I don't know how anybody can get mad at me for pointing it out. I really can't. Even Sandy would be mad at me, and she knows I love her, and she knows that because she adores KZ in every way, and she should, but she gets upset with me too. So I'm sorry, Sandy, if you're watching, if you're lurking, but she knows how I am. Steve knows too. Do I think they'll get through the procedural bar? Okay, let's see. The new witness, let's go through the steps of that. He says that he called Manitowoc immediately after the rat was found. We have no record of that as far as we know. So there's no way that we could have known about it back then. He sent a letter to the Innocence Project. I do not remember the dates. Maybe somebody else does. Not important, but it was a while ago. We would have no way of knowing that. He sent an email to the attorneys after Ma'am was aired to Steve and Jerry. Steve and Jerry. Jerry and Dean. Okay, yes. To Jerry and Dean. You tell it's late. And they have no record of it. That they've said. So again, there's no way that Kathleen could know about that. So it came to her attention at a time when, and she filed the claim right after it came to her attention. So I don't see how that can be procedurally barred. There's no way they could have known that about that call or about that witness. So that shouldn't be procedurally barred. What was the other one, Sue? Because I already forgot. And I already lost your question. What was the other one that we were talking about? I'm just drawing a blank now. About what was the other one? The flyover video? Was that it? I don't know if it was or not, but the flyover video email, again, that was obtained via FOIA request. So again, I don't know how an attorney would be expected to get another attorney's on the opposite side's emails. That's not something that's standard that you ask for. So no, that should not be procedurally barred either. Oh yeah, those were the two things. I just saw your question again. I'm scrolling back and forth so fast, so I keep missing everything. Sabercop, I have given up on that happening. If you would have asked me 5 years ago what I thought was going to happen, I thought for sure somebody was gonna cave at the documentary, you know, or after KZ came on board and started putting pressure on people. I thought for sure somebody was going to be the weak link. I most likely thought it was going to be Colburn, but and that somebody was going to finally, you know, come forward. And since that has not happened, I do not see much hope of it ever happening. You're funny. No, that would never, ever happen. Ever, ever, ever. Nor could she. She couldn't. She actually could never admit it if she made a mistake. She'd be opening herself up to malpractice lawsuit. So, yeah, she could never do that. And she's, you know, now if it ever came up in court, then yeah, she could do like, because like that's what Jerry and Dean are doing now. You know, when you bring up IEC claims, they are filing affidavits saying, yeah, I screwed up. So yeah, that's totally a different situation. But as far as right now, no, she's never going to say that. Nope. And I'm sure she'd have some real choice where she doesn't like me anyway. So it's fine. She already doesn't like me, so I don't care. I scrolled so far back that now I don't know if anybody asked anything. I'm sorry, you guys. Yeah, it was sent to the Innocence Project. I just couldn't remember the date on that. And then it was sent to Brenda says Ben and Jerry. Yeah, I said Steve and Jerry, whatever. To Jerry and Dean, and they have said they never received it. What is the best piece of news, most positive thing to come out of this judge's response? Well, I said that just the fact that there are issues that they can still bring up in another petition, whether, you know, we think those are strong claims or not. Just the fact that that it's not dead. You know, it'd be really easy at this point to think that everything was just completely dead, and she had to really start over, like finding completely new evidence. So, you know, that the fact that there is some stuff that can still be there is good news. Could KZ have evidence of the email to previous lawyers via the witnesses and email history? Wow, I'm having trouble processing. Sorry. His sent email history. Yeah, I have no idea. I'm sure she's exhausted all options as far as, but they were sent a while ago. So yeah, I'm sure her investigators have talked to that guy several times. They visited him. So I'm sure that they have actually tried to use every thing they can to try to find him or get a hold of him. We already talked about that one. If she files a motion for reconsideration, she can point out any inaccuracies. And but you know, again, a motion for reconsideration she might not even file them, to be honest. If she doesn't think it's worth it, she does not have to file a motion for reconsideration. She does not have to petition the Supreme Court. That is completely at her discretion. If she thinks it's better for her just to move forward with a new petition, she can do that too. Because, you know, it's always waiting anytime you file something. Yeah, and I think that's what they were flat out saying. They brought up the Denny motion. They said the new witness and the flyover video could both link nicely with Bobby being linked to the crime. And then you take the before mentioned issue of the CD and the contents of the CD, and you can't bring that up again as far as a claim, as far as an IAC claim or a Brady claim. She can try to bring up the IAC claim, but I think it's going to be procedurally barred. I mean, that's why I wish she could have brought it up the first time. I don't know why she didn't. But all of those things now strengthen the argument that had the original attorneys dug more, that he would have been a Denny, a suspect that could have been presented during the trial. The Denny evidence never should have been disallowed, I should say, from the trial. How come it always looks like it says porn? Sorry, Julie. Like when it's little, I can tell here. Glad to hear that, porn. That's what I keep saying. Every time I see Palm, I see porn. Julie, porn. Sorry. Even if she doesn't like you. Yeah, no, she doesn't like me. We already know this. She should hire me. I know Kathleen or Christine actually said that once. She should hire me. I'm like, yeah, she should. I'd work for free. Actually, I probably wouldn't now. This was back when I was still like, really heavily involved, and I don't do as much anymore because my brain's stupid. I get too confused too quickly. I can't do things. This is Tracy during her best classes half full routine. That does not come naturally for me. I am a pessimist at heart. You know that. There are times I'm telling you guys, like sometimes I feel bad because I am kind of like trying to be positive for you. And in my head, I'm like, nope. But right now I'm being honest. I think it's always good to have hope. That's why I'm saying I'm not going to give you any type of, odds of what of this is going to work or not. We're not far enough into it yet. But I always think that it's best that you can at least have somewhere to go. Will KZ respond or appeal? This was the appeal. You can't appeal an appeal. She can petition the Supreme Court to hear the case, but that's essentially it. This is just like Brendan's case. Once the Court of Appeals hears the case, if the Supreme Court doesn't take it, this is it. That's it. It's final. And all those issues are finally adjudicated unless there's some newly discovered evidence to bring them up again. And yes, she will ask for another judge. There's no way she's sending another thing in front of that judge. Tracy is coming from logic, not feelings, except for when I was crying. I got into my feelings for a little bit. I can't help it. I think of Steve and I just think that it upsets me a lot. And I know everybody gets upset, but I've sat across this table from Steve. So actually being able to envision him and seeing him hurt. And I've seen him in tears before. So yeah, I can envision that right now. And it's hard. Thanks, guys. Thanks, everyone. I appreciate it. I appreciate the love. I need it. I certainly need it. Thanks for sticking around. It is heartbreaking. It is very heartbreaking. And I'm going to continue to ask everybody, even if you're not the praying type, send send some prayers to Steve, say some prayers for him. If you're not the praying type, just send some good vibes, good thoughts, good juju, whatever you do. Because I'm very worried about him. I was worried about him after Dolores died. Anybody that knows anything about Steve knows that his mom was the most important person in the world to him. And I was quite concerned. I really, truly believed that the only reason why he was able to handle it is because he knew that he still had this decision coming. And now so soon after that to get a denial. But Kathleen has always done a really good job at keeping Steve positive. And so that's what I'm hoping for, that once she talks to him and explains what's going on, what she's going to be doing, that he'll know that all hope is not lost. But I would still say, please just keep Steve in your prayers because I am very concerned for him and his well-being right now. Yeah, I think the fight has just about gone out of him, but hopefully there's enough of a light here to let him know. I mean, he never gave up before and he was in longer than this. It's just he's older now. And the hardest part is that his entire motivation for wanting to get out was to be with his mom and dad. So I just don't think he cares as much anymore about that. I think Sandy told him, I'm not sure. I'm not sure if he heard it from Sandy or if he might have heard it from KZ. He was supposed to talk to Kathleen this afternoon. Sandy had already talked to him several times this morning. So I'm not sure who actually told him, but he might have just called Sandy and she might have just told him. I'm not sure. because it's a lot easier for him to call Sandy than to call Kathleen. So he might have just found out from Sandy. I'm not sure. And let's face it, it was probably all over the news. So it would have traveled through the prison. And there's Travis still answering questions in the chat. Good. Thank you, Travis. Because I'm getting confused. He can be. Let's put it that way. I'll just say that. That's something that, if necessary, will be considered. I do not know if he is right now, though. I believe he should be. If you want my honest opinion, I believe that he should be. Okay, so is that it? Thanks, everybody. The thing is now, we might have a few little things. Again, Kathleen might file a motion for reconsideration. I'll post them if she does. I don't see that I'll be doing a video on them because I can't imagine there's much information there. So that means that, you know, there probably won't be much news again other than that until she files another petition. So we're back to waiting again. And it's hard. You wait so long and then something happens and then you just wait again. And unfortunately, that's what it is. But everybody should try to just keep doing what you're doing. Keep Steve's name, you know, in the media. Keep them for good reasons, not bad reasons. You know what I mean? Keep supporting and doing everything that you are. So yes, keep sending him letters. You can send stuff to his commissary. I used to have banners. Where did my banners go? I don't know if I got rid of them. Oh no, like they're here somewhere. So I can't find the one I'm looking for. Oh, here it is. accesscorrections.com is where you can send money to Steve's commissary if you would like. So I'll leave that up for mission. So that's it. Travis, of course you would ask me that question. I don't know. I don't know it right offhand. Travis asked, what's the time for appeal? I have not read procedure in so long. I can look it up if you really want to know, but you can look it up too. How many days does she have to file for motion for reconsideration? 14 maybe? I don't know. Maybe 30. I can post. I'll post it in my group. I'll look it up and I'll post it if I find it. Okay. I gotta end this now. So I will talk to y'all soon. Love you guys. Thank you so much for being with me and thanks for the support. I appreciate it. And thanks for not getting mad at me. Everybody have a good night. Bye.